Hey, what's going on? Welcome to Unreasonable Doubt, along with my favorite friends, Mr. Judge Franklin Bynum. Hello.
Hey, I'm back. Yeah, I'm back.
Our producer extraordinaire, Mr. Justin Harris.
Hi, thanks for dragging me out.
And the smartest one in the group today, ladies and gentlemen,
hands
Mrs.
down.
Sarah V. Wood.
How's it going?
Another
Glad to be
week,
back.
another week at the courthouse. We got a judge, trial warrior, upper level PD. Let's talk about
And
some.
me.
It's a trial
You're the
warrior.
warrior.
Yeah.
Oh,
yeah,
no.
yeah.
Yeah.
I heard you got a big not guilty this week.
Oh, a little not guilty on like a trumped up traffic ticket. It was a racing case.
Oh, you mean you?
Oh, I heard
You
about
got a
the
not
racing
guilty on a
case.
race?
Yeah, way to go. Yeah,
Oh.
what was that about?
Did they do the horns?
It was awesome. Like the video looked really bad for us. I mean, it looked really bad, and the jury completely restored my faith in this whole process because we went back there and talked to them, and they looked at the prosecutor like, we did exactly what you said. We wrote out every one of the elements, and then we weighed all the evidence for each element, and we think he was probably racing, but we didn't think it rose to beyond a reasonable doubt.
Did you use
Wow.
I was like,
Did you use a chart in the voir dire or closing?
I didn't. Like the stair step chart, no, I didn't. And I was impressed by we talked about it, but I didn't use like a visual. And I was really impressed by this jurors.
Have you seen, how was your makeup of your veneer panel? And did you feel like it was old, young?
It was interesting. So I had 30 on the panel. I had 3 African Americans. I had a slightly over-representation of the county on Asian Americans, under-representation on African Americans and Hispanics.
What about whites?
Whites, I think, were represented because of the low numbers for Hispanics and African Americans. I objected to the veneer panel based on not being representation in the cross-section. The judge
Did you?
disagreed with that. The state struck the only 2 black jurors in the first 15 after the causal strikes.
Racist.
I did a Batson challenge on that.
Did you win any?
No. I mean,
Who was presiding?
Judge Genesis Draper.
Really? How was she in trial?
I have to say, I have tried a case. We picked a jury. We busted the panel, so we didn't get very far. So I can't speak for all of the county court judges because I haven't tried a case in front of them. But this was easily the most fair jury trial that I've ever sat through. I mean, she shut me down on things she should have shut me down on. She shut the state down on things that she should have shut them down on. I mean, it was even keel.
Before we start talking about judges, let's talk about the panels and people that are coming through. So, Judge, you see panels, you try cases in your court. Are you seeing? Talk to us about the cross sections you're seeing.
You know, I think that the trend line is good, you know, as far as we're getting more and more representative juries, jury panels, and but I would say that we're doing more with what we got, you know. I mean,
Sure.
in the sense that, like, my job as a defense lawyer, right, was like begging and pleading with people to, like, please follow the law, right? And it's somewhat different now because my job now is I just get up in front of them and it's like, look, you got to do this, right? If you can't do this, just tell me, but you have to, right?
Mm-hmm.
I'm up here telling you got to do this. So if you can't, let me know. And, like, it works, you know. People will.
Do you do a voir dire or do you?
I do some. I
voir
do
dire?
less and less. I do less and less. You know, I want to let the parties honestly take care of it. But I will say, as far as, like, you know, having faith in people and really, I say when I do the parts that I do, I say that, like, this is the part. Yeah, that's right.
Do.
The parts of the voir dire that I do, one of the things I always say is that this is one of the last parts of our democracy that the people really truly have the power, you know.
Directly.
And it's so directly, and it's so important. And I talk about it in terms of, like, giving my power over to you, right? Y'all are the judges, and we rise for the jury in Texas, right? We don't do that in other states. We rise for the jury because they are the judges of the facts. And so we talk about jury selection in terms of recusal. You know, if you wouldn't be good for a certain case, you know, I let people know when I'm not good for a case, and, you know, I expect you to too. Recuse yourself from being a judge in this case. But let me say this: I've been working real hard on making the jury instructions better. You know, like before they were a text blob, no one really cared, you know, whether they were readable or usable. Been breaking things out, complex ideas, right, into bullet points, right, saying here, you know, a lot of these are confusing issues, right, as far as like you don't have to be unanimous about these two things, right, but you do about the one thing that covers these two things. If you put that into bullet points and refer to them as 2A, 2B, people understand that better, at least. And I think that people do the right thing if they have the right instructions.
So let me ask a question on that. Do you think that when they're not clear and they're a little bit more confusing, or they use more legalese or cumbersome language, do you think that benefits one side over the other?
I do. If they can't put a thing in common terms, and I think they're going to lose something. If you're going to put a slide up in front of a veneer panel, it better not be cumbersome, and it better be broken down.
Right.
You better have thought about it.
As far as the jury instructions go, though, because that's what's such gibberish.
Well, and on the jury instructions, I think that if you're going to just agree to the form jury form jury things that we pull and that are used to in Harris County, you might run into some problems. I like to, if I have a special issue or a thing that I need to be in the instruction, I like to have a written out, kind of case law backed thing that I can submit.
I don't use the Harris County charge bank. I mean, just to like back it up and explain to the audience of, you know, however many, right? Like, we used to have this thing called the Harris County charge bank, which I don't know where it came from, right? But basically, there are instructions given to juries at the end of a jury trial. And we had our own instructions in Harris County for a long time. And I don't know where they came from, again. But I use the state bar jury charges, right?
Sure.
And the thing is, if you go to the book, right, it's really like thoughtfully, they're like, well, here, you could include this provision, here's the case law behind this, or you can not, this is arguable. And it's just much better, much clearer. And then I further break it down. I use a nice font. I try to use a nice font.
What do you like?
I've been using IBM Plex monospace.
I'm serious. Gil Sans is a real good one too. The Gil Sans, I like
You
that.
get more not guilties when you use Gil Sans?
Sometimes the Courier News, I get a little bit more like pop to it.
Yeah.
So the best story I ever heard about jury confusion was somebody went to trial on a case that was just like an absolute loser. And they were like, okay, there's just no way that we're going to win. They had to go to trial for some reason. And the jury came back with a not guilty, and everybody was just completely shocked. And they went back and talked to the jury afterward. And the jury was like, well, you know, every time you said objection and the judge said overruled, we knew that we weren't supposed to consider any of that evidence. So we followed the rules.
Let me ask
And
you.
of course, the funny part of that is that overruled means that the question was fine as far as the judge is concerned, and they can answer the question, right? And the jury can consider that.
Jury had it completely backwards.
Yeah.
It's so important. It's so important to explain that flow of the trial as it's happening, you know? So I find that just as a basic courtesy and maybe more kind or accommodating to civilian witnesses than police witnesses, right? That I'm like, oh, thank you for your testimony today. Or the other way, I had a police officer once like offer his hand up as he left the stand in front of the jury, and reflexively, I just offer my hand back. Oh, yeah, thank you so much for coming. But every time I do anything like that, like thank you for coming to a civilian or shaking the hand of a police officer, I always think to look at them and be like, hey, you know, if I give courtesies to a witness, if I exchange some pleasantries, like that's not me making any comment on what they just said. It's just me trying to be like a kind and courteous person, right? And you're not to like really consider that for anything. And I think that like juries often complain that we get the instructions at the end. And it's like that is a bad way of doing things. But I explain it to them in terms of which are correct, which I don't know what the instructions are until the end.
It plays out.
But there are some intermediate things that I can slip in that are not at all objectionable that can let them understand what's happening, and I try to slip those in when I can.
Well, before you jump on, I want to read a portion of a jury charge instruction that I think we may have all heard before. This is one that I've really been starting having some problems with. Before I do, let's real briefly explain. At the end of a jury trial, the jury's about to get the case, and the judge has a set, and they're 8, 10, 12, 20 pages long, of written instructions of the law and everything that the jury's supposed to go back and be able to use as a rubric, right? So it tells them everything about the definitions of the terms. It tells them what they can consider, what they can't consider, how to consider things, how to apply things. If there's a special issue like self-defense, it applies that for them, right? So this is some language that I started having some problems with, and it says, this is under the section about evidence. It says, evidence consists of testimony and exhibits admitted in a trial, and tells them what evidence is and what they consider. It goes on and says, statements made by the lawyers are not evidence. You heard this before? Mm-hmm. The questions asked by the attorneys are not evidence. I have a big problem with that, because as defense attorneys like you and me, JV, and Sarah, our questions are, most of the time, are in cross-examination, right? Right? Mm-hmm. And what's the answer to a well-crafted cross-examination question?
One
Yes or
letter?
no.
Yes or no, right? And I know that Judge Bynum may not be able to mention much about this because this issue might come up in front of him if somebody objects to it. So feel free to jump in where you can, but I direct this to the people who feel like they can answer. I feel like
I'm okay
that was
with
written.
it. I'm okay with that.
But if the jury gets back there and they're like, well, wait, we can't consider what the defense attorney said because everything the attorneys say are not evidence. So all we're left with are a bunch of yeses and nos without any context. I think that was written by someone who just does direct examinations, by a prosecutor. And I think that was thrown in there with the intent
cut
to
it out. Are you trying to cut it out?
I have cut it
Judge
out.
Draper?
In the last couple trials, I've cut it out.
They cut it out?
Yeah.
Are you
But
serious?
the state fought against it.
Of course they did.
And the judge had to explain to the state, well, no, because if you take out all the questions the attorneys ask on cross-examination, you're just left with yes and no's. You have to have the context of the question to know what the yes or the no is for.
But when you ask a leading question and the juror says yes, that they agree with it, then they've adopted your question, basically.
But if you're a juror and
Which
you
I
don't
think
know
is-
that, you are the most intelligent and well-informed person in this room right now. You know that because you've read case after case after case. You have the years and years of
It's
experience.
just common sense, though.
Is it though?
Maybe.
If
I
you're
mean,
not that, if you
There's
don't
another
have
part
that
of the
much common
instructions.
sense.
And what's the other part of the what's the other part of the
It talks about,
instruction?
using your common sense,
Sure.
something like that. I get what you're saying. I hear you. And there has to be a better way, right? That is one way of doing it. I think that there has to be a better way.
Well, we just cut that out because the next sentence in here is that evidence consists of the testimony of the witnesses and materials admitted into the record. So,
Yeah.
like, you just cut out those first two sentences
That's
and
all
leave
you
it
need.
with that.
Yeah.
You can just tell them what evidence is
Yeah.
without telling them what evidence is not.
I think it is
Yeah.
helpful to tell people that what the lawyers say is not, because often lawyers will, overpromise and they will ask questions that
I love
assume
it.
facts, not in evidence.
You
right,
made this
without
up,
an
didn't
objection,
you? And then you hit yourself.
But
that's
yeah,
true.
and
Okay.
so-
But cross-examinations do that.
Well-
right? And
Right.
so if you don't want someone to consider a fact not in evidence, which doesn't come out generally in direct examination.
most people don't understand what that objection is.
Right.
And it really is an important objection, right? We
It
should
is.
all
But it comes out that happens more on cross-examination.
Right.
So if you want to undercut your opponent for their cross-examination questions, then you put this in there that may confuse some jurors who don't maybe come into the jury room with as much common sense as we would like or as other people have. But I think that if you don't understand everything and you don't know that by saying yes or no to something that you adopt the underlying predicate of that question, that might confuse you. And that might make you end up disregarding pretty much
think
the
you're right.
entire defense.
Yeah,
I think you're right.
I think it's mostly for like opening statement, like you were saying though. 'Cause I had an appeal where the lawyer got up in opening statement. It was injury to a child, and he promised the jury that this was going to be about reasonable discipline, and that yes, he spanked the kid, but it was for a reason, and it wasn't too hard, And then the kid testified at trial later that it never even happened, and he made the whole thing up.
Ooh.
Yeah, it's ouch.
How you like them, Judge? Have you had to deal with any sort of nature of the relationship or forfeiture by wrongdoing kind of stuff in your court? Anything about that?
I don't
That
think
stuff
I
sucks.
don't think that I've had to deal with that.
So it's terrible. Nature of the relationship in assault family member cases, they borrowed it from the old murder statute where you can talk about the nature of the relationship still subject to the rules of evidence regarding the relationship between person A and person B, and it's not character evidence. It's just other motive, intent.
Right, 404B.
Right, that's
Yeah.
correct. 404B2.
Yeah.
Is it direct evidence or is
It's
it?
dude. It's anything subject to basically 404. It's pretty crazy, and forfeiture by wrongdoing is pretty terrible too. I don't know if you guys are looking into any of that stuff, but if once the prosecutor's office catches on to nature of the relationship, forfeiture of wrongdoing, we're gonna have big problems on the defense side.
So I mean, like, you're hoping that none of them are watching.
And I'm loving
Yeah.
that I'm not talking
Yeah.
about it on.
Yeah.
Well,
it's the
you know,
law.
we just had, a whole bunch. Like last week was so-called baby DA school, right, where all the younger DAs go.
Is that where
their
they all
annual
were?
training. Yeah, that's where they all were. You know, it's funny. We have a baby judge school that was just an abomination, right? It's like, oh, now I realize why the quality of the judiciary for the 10 years I practiced before was so poor across the state, because I went to baby judge school and like. They didn't say, many of these new judges that were going to this new training, they weren't even on the bench yet, right? They're coming straight from DA's offices, they're coming straight from civil practices, they're coming straight into many of these district courts in smaller counties, handle criminal and civil matters, right? In Harris County is the exception that we separate them. And, not a word about criminal discovery, not a single word.
Really?
Not a word about suppression, constitutional standards about search and seizure, not a word about it. The only time they talked about criminal cases were to say that, and I'm not exaggerating, right, that criminal defendants are, and I use that term intentionally talking about the program, right? Criminal defendants are never show to court, and it's a huge problem, and that they're trying to kill you. You personally, you judge, you listening to this, criminal defendants trying to kill you.
Is this
right?
where we're supposed to use the shocked expression on TV? Like,
No, that's later. That's later.
Oh, but who's teaching this?
So it's funny you asked that. It's taught by, believe it or not, a former Harris County criminal court judge named Mark Atkinson, who was Court 13 judge for many years, and who cornered me at the coffee urn one day when I blew off a morning to get on a conference call regarding the O'Donnell bail lawsuit about dismantling the system that he helped build. And so I took the morning off of class, and he cornered me at the coffee urn to talk about how.
I heard about that. That was not in Austin or something.
wait.
Yeah, that
How
was in
what?
Austin.
Yeah, I heard about that.
how disrespectful it was
Yeah.
for me to blow off a morning of a
Right.
5-day CLE, and I'm like, look, man, I'm busy. I'm
Dude.
busy with problems you gave me.
Created, right?
How is it standing up to, because you've taken some positions that are 180
Well-
from some in the last 20 years.
Can you hold on for that second? Because I've
Sure.
actually been thinking a lot. I had a client in my, so I was running a little bit late. I had a client in my office, and I wanted to ask a judge about just the timing of a docket tomorrow, and I happened to have his cell phone from before he was a judge, and I held back because I was like, I don't know if this is appropriate or inappropriate, and I assumed in my mind that when y'all go off to that training, that they cover things like, here's how to be appropriate with your friends who you're going to be practicing in your court, and here's how to handle 3914 under the Code of Criminal Procedure. And you're saying that basically
That would have been great.
absolutely none of that happens.
There were some weird cutouts in the back table with the coffee of like a Bible verse about do unto Israelites as you would do unto other Israelites or something along those. I mean, I'm sorry I'm watching the Bible on television, but it was something about Israelites, and it's just like.
That is amazing.
It was astonishing to me the poor quality
Who puts it? So Atkinson was like the course director, or
It's the Texas Center for the Judiciary, and that is grant funded by the Court of Criminal Appeals.
And but it weren't your classes mostly about civil practice? Everything
lot
is
of them-
civil centric.
It was very civil centric, and it was just like, criminal cases. It's just like they're trying to kill you and they never show up to court. It's just like it's like a nuisance almost, right? And I will
Shocking.
say one story about this that I love. My favorite story about Baby DA School is that,
Judge
or
School?
Baby Judge School. I'm so sorry because we started talking about Baby DA School.
Yo.
Is I sat at the table with many of the new Harris County criminal court judges, right? And I am so glad to be in the minority, right, with a number of colleagues who are people of color, and I was sitting at the table with them because they're my friends. And they told the story, the topic was recusal, right? And so somebody told the story like, well, you know, when you get that phone call, you ought to pick it up, you ought to answer. It's a hassle, but it might change your life. Let me tell you a story about a case I took in a county where the DA got a wrongful conviction, but then it turns out that he was now a judge and the whole county was conflicted out, right?
Oh, yeah.
If you're in the know, you know what I'm talking
Yeah.
about, right? And we did too. And he was like, and it turns out that I presided over the exoneration of Michael Morton, and who is the wrongfully convicted person in Georgetown, Texas, Williamson County, that the discovery law that we have, the strong discovery law in Texas we have, is named after him. And he was like, and that prosecutor who wrongfully convicted him, he lost his bench and he was disbarred. And from our table of Harris County judges, I started a round of applause at Ken Anderson being disbarred.
Yes.
And I looked over at them, and there was this reluctant applause, this uncomfortable, reluctant applause started like spilling out across the room. And I looked at my colleagues and I said, you know, we just started probably the first round of applause for Ken Anderson being disbarred in the history of baby judge school.
Well,
Good.
That's awesome.
Shouldn't that be something? Yeah, that is applauded. Yes.
Yes.
Yes. Yes. Yes, man. How have you been? How have you dealt with the realities of being a judge with, in my opinion, would be reasonable views like a fair system, but would be considered radical? You know, a year and a half ago, you've been nationally publicized about your views. You were a hotly contested bench in county criminal court at law number 8. What have you been able to do personally to make it through? And what are some of the challenges that you see on the horizon that for criminal justice? I don't know, I'm not going to say reform because I don't think that maybe that's not your platform at all, but it is radical or changing what used to be the norm.
People like it.
Well, how have you been able to deal with that, man? I mean,
The day-to-day, I got to say, and this goes back to the bringing up baby DA school last week, right? It's like the day-to-day in my court, I hope, I think, talking to litigants, right, is like everyone's treated well, right? Prosecutors treated well, defense lawyers treated well, most of all, people charged are treated well, the staff are treated well. So, like, you know, there was all this worry about, the big bad, you know. I mean, I remember when I first met Kim Ogg, I'd never met her before. We went to some, like, dinner, and she comes up to me and she says, well, you know, Franklin Bynum, I hear you're going to tear it all down. And I said, yeah, I am. But she's like, well, I'm not going to worry about that. I'm just going to wait and see what it means. And I was like, well, better not to worry. That's what my therapist tells me. And so, you know, like, the day-to-day of like we were talking about last week, the line prosecutors, right, is, I think, probably pretty good. I mean, they went to baby DA school, and I was just like, y'all don't ruin my reputation, right, by saying that it's actually a good place to practice, right? Talk about how horrible I am. You know, the way it's done, right, the way that I accomplish the larger things that I talk about in places like this and out in the world is just day-to-day treating people well, right? And it's easy.
There was an article written about you regarding something about abolishing prisons. Was it prisons or jails?
It's prison abolition, right?
Okay,
Yeah,
prison abolition.
Yes.
What does that mean, and where are you going with that?
Prison abolition is a big idea that has roots in the larger abolitionist movement that we're all familiar with, right? The abolition of slavery, right? Prison abolition is the idea that, and the way I explain to people in the courthouse is this: we deploy police and prosecutors towards social problems that we should not, that police and prosecutors are not equipped to handle. And so one of my colleagues came in when we were at the Family Law Center, this temporary building, and I had this great panoramic view of the whole jail complex. Now I have a window view of it. And I said, look, if I could wave my hands and get rid of this jail complex, I would, right? It's not any way for us to live together. It's not. But I can't do that, right? What I can do is talk to people about what we're doing and why it's wrong, day to day, treat people well, put it into action, and say, this is the wrong solution to this is the wrong solution to this DWI second, this is the wrong solution to this PCS case, possession controlled substance case. and day to day do it and show people that it is the wrong solution. And in a larger sense, we need to redirect resources from very, very expensive police and prosecutors towards giving people housing, giving people health care. Like one of the taglines, one of the put it on a bumper sticker ways to say it is people need care, not cages.
Sure.
And that's what prison abolition is, right? In a larger sense, prison abolition is a goal. And if we go at this system and we stop deploying police and prosecutors for mental illness, for poverty, for any number of other social problems, what we're going to be left with is not prisons as we know them, right? That is prison abolition, right? And it's not some shrunk down version of the system. It is an elimination of this system. This system is a continuation of some of the worst, most shameful practices of our country and of our history, of our people, of everything, right? And we have to stop it. And it's a big task. And a lot of people blanch at the term abolition, right? A prison abolition, right? As if we're going to like go there with an axe and, you know, with cut open the gates, right? And open the floodgates. No, right? It is changing the way we live, changing the way we think about punishment, retribution, and peeling these things back and building a better world for ourselves.
It didn't used to always be this way. So like right now, and you know, for a long time, prison abolition seemed so radical and like it would change everything. But in the 40s and 50s, like that was mainstream thought. And if you look at the incarcerated population, it wasn't until like the 60s, the war on drugs, that it really skyrocketed. But before then, like it was low and it was going down. And so prison abolition was actually mainstream academic thought. Nobody thought it was crazy. It's happened in other places in the world.
You mean to tell me that if instead of incarcerating these individuals, we could maybe educate them and teach them, and they would come out in our society and actually produce?
So
that's insane.
So
produce some capitalists, but or just be normal, live among us, right? I mean, we all, as a defense lawyer, I did. I mean, the instances of people that like truly, right, that we can't live with, that can't make it out here for whatever reason, real low. You know, I mean, everyone's so afraid of like, oh, what about the murderers, right? Well, the recidivism rate for murder is real low.
Yeah, that's true.
It's very traumatic to kill someone else. Mm-hmm. Most people do it, kind of in the heat of a moment or something, not excusing it, right? But then to compound the harm, right, in a way that in many ways ripples out far greater. You know, we need to take a step back and look at what we're doing to ourselves as a society.
In other countries, they don't give these high sentences. Like in Australia, they would give 14 years for murder, and everybody thought that was a super long time.
That is a long time.
It is a long time.
That is a long
but in
time.
America, it's like, that's a slap on the wrist, which is insane. And, okay, so, like, we have this idea that we've been batting around. All right, so, like, in the UK, when the police respond to a situation, instead of, like, in Harris County, when they, respond to a disturbance or whatever, they call the DA's office and tell them what's going on and ask them if they're going to accept criminal charges. But, like, in Europe, instead of calling the DA's office, they call a completely separate agency. They explain the situation, and that agency sends them to, family services, children's services, mental health care, hospital, whatever social services the situation calls for. And it's only a very small percentage of the cases that actually get referred for criminal prosecution.
Right. I mean,
it just makes so much sense.
And the thing is, it's really important. It's such an important point because so much of the reform we've done in Harris County has gone so fast because we have such a centralized system. And one of the ways that our system here in Harris County is the most centralized is what's called DA intake. When it doesn't work this way in other cities. The police officer calls a DA from the street and says, hey, I got this person here. Self-checkout at Walmart, sit-go parking lot, or, somebody got stabbed and I think this might be the guy, right? And let me tell you why. And the DA actually on the phone accepts or rejects those charges against that person. So the DA, in ways far greater than other cities, enacts personal supervision of street police conduct. And so, what if we were just to divert that line that the county controls, right, the commissioner's court controls, to somewhere else? Why should the DA get all those calls, right? Why doesn't someone else get the calls and then decide if they'll forward it to the DA if that's what's appropriate?
Well, if you don't get the calls, you can't ask for the money.
Right.
And they do like to do that.
Hey,
They're working on it.
reasonable doubt. Come in peace. Call 713-807-1794. Catch us on Twitter at HCCLA_.org.
_org, no dot.
Oh, Twitter at HCCLA_org. Come on, hit us up with Honorable Judge Franklin, Justin Harris, Sarah V. Wood.
So I want to give you a little bit of bad news about what you were saying about prison abolition. So the JPC, which you talked about last week, and how it's no longer, it's not ideal, but it's not a dungeon anymore, a literal dungeon, I think is what you said, like the IPC was. So I had a client who was taken into custody yesterday. We knew what was going on, and he called last night, a free call from the JPC. He'd been in the system a long time, or quite a bit, a long time ago. And he called last night just to tell me how great and wonderful the JPC is and how it's just awesome. And he was just kicking it, watching TV, and things have really improved. He didn't even tell me, like, I've got to get out of here.
So when they go and be like, hey,
Wow.
bro, you want to take the time serve? He's like, nah.
Can you get like another
man.
weekend?
I'm good. Hey, so let's talk about...
Nobody wants to be in jail.
Nobody does. And the thing is,
But
I
that
look
is a
forward
marked
to-
improvement. I did want to tell you that.
Thank you. It is uncomfortable for me having the feelings that I feel, to speak about a jail, a cage, in the way that I would speak about the JPC. It is an incremental improvement, right? And I'm glad to be here for it in a building that I have a blue badge and I can beep, it opens gates and I can use my signature to free people from it, right? That is a big improvement from people being not just at the IPC county-owned dungeon, but maybe being under the control of HPD before at a jail that I don't have a blue badge, right? HPD is not going to let me into their jail to free people, right? They're not interested in that. But now it's a building that I have access to, and it is an improvement. But the thing is, I look forward to the time that the JPC is like a community center or a high school, because it's probably the same architect as a high school.
Did you see the chief of police or whoever it was yelling at the judges about letting people out on violent crime, on low bonds and such? And then they said the amount of the bond, and I thought it was completely fair and reasonable. Did y'all hear about that? I mean, it's all over the news.
It was 50,000, right?
Yeah, I was like, dude, I thought 50,000.
What was the case?
He ended up shooting somebody. The accusation is somebody shot another individual in the face while on bond on some other type
The
of
bond
crime.
schedule back in the day, capped out at about $35K, $50K for anything,
Yeah.
murder, sort of capital murder, This is the wrong thinking in terms of release tied to a dollar amount, right? This is the old thinking, right? And whenever, believe me, it doesn't surprise me that law enforcement, even in the higher ranks, right, does not understand the law and the Constitution, right? They don't. It has nothing to do with the money amount. And in fact, if you do what they say, and you just make ever increasing amounts, who are the only people who can afford $200K, $300K, $500K bond?
Rich people.
Well,
Or really, really good criminals.
or right, like people like
ones you
people
really don't want
like
out.
organized crime,
Yeah.
right? I mean, not to concede any of these things exist as they allege it or any,
Sure.
but yeah, right? It's like people like Robert Durst who were born with a whole bunch of money, right? And people who are in business, right? And so what they're saying benefits like the people that they would say are the worst, right?
Right.
Yeah.
At the expense of the normal, regular people here who are caught up in the system, the law, and the Constitution says they're innocent. It's outrageous to tie these things to money. It's archaic. It is 100-year-old thinking.
It makes absolutely no sense. I mean, there is, no one can, if anybody can explain, please tell me, like, how is it, okay, I mean, like, the 2 points, the two, factors to consider in bail is safety of the community. Is the community going to be safe if this person is released while they're waiting for trial? And are they going to show back up for court? Those are the two things that you have to consider when deciding whether to release somebody. How is it going to make you any more likely to come to court or any more likely to not commit another offense to pay $5,000 to a bondsman? Okay,
Right.
Doesn't.
so I mean, like, if
You're never going to get that $5,000 back.
you're never going to get it back. Like, maybe if you were paying it directly to the county and they were actually holding it as
Yeah.
a deposit for your appearance, that would make you more likely to go to court, knowing that you would get that money back. But giving it to a bondsman takes all of the logic completely out of this.
This whole county,
completely.
myself included, is living paycheck to paycheck. That is how people live. It's not like you have some gold in the back and you got to put the gold up to secure your freedom, right? That's not the world we live in. We're all living paycheck to paycheck.
So let's talk. Okay, so let's talk about it. There's a big deals going on. Settlement talks, settlements, signatures on the paper. Big bail lawsuit. Is it finally over? Where are we at now?
It's just about over. So to give some background, a few years ago, the county was sued in a case called O'Donnell versus Harris County. Miranda O'Donnell is the name of the person who is a representative of a larger class of people who was detained in the Harris County Jail because they couldn't afford to pay to get out. And we took over the system in January, and I think we talked a little bit about it last week, and made some temporary changes to end that system of wealth-based detention. And we did it through the local rules and check the YouTube for the details. But what we were in court today for was, this was as a criminal defense lawyer would put it, the plea or trial setting, right? This was the no more resets, the work this case out or not setting. And we have been working round the clock to make the temporary changes we made part of a larger scheme of permanent changes that will make sure that no one in Harris County ever again is locked up because they can't afford to pay to get out on a misdemeanor. And we went in, and I'm so happy to say that our lawyers announced on our behalf that we have reached a settlement in principle. It'll be on the Commissioner's Court agenda this Tuesday, and that we did it.
Do you have any highlights that you can share with us for this agreement in principle that will be before the Commissioner's Court?
It's a big, big document.
Okay.
Some of the highlights that might be interesting to people, aside from locking in permanently the changes to local rules guaranteeing release for people, is we are going to provide more support services to defense lawyers. Right now the county courts maintain a list of lawyers that you can get appointed a lawyer. We're going to start maintaining lists of investigators, lists of social workers, lists of help that defense lawyers can access without a lot of the red tape that has been in existence before, right? We're cutting out the red tape and saying, if you need help, here is help.
And these are social workers not to help the lawyer with their personal struggles. These are them to help their clients.
Right.
They're investigators to help investigate their cases and experts to help investigate. These are people to help the defendants, right?
Yes. People to help the defendants. We're recharacterizing a lot of the settings, right? It's a big problem in the courthouse that we're jamming people into the courthouse that don't need to be there. So we're setting into letters that for certain types of kind of intermediate kind of settings, court settings that are not important for people to be there, we're just putting into the letter that if an attorney shows up, that's good enough.
Awesome.
Really?
Yes.
So appearances don't have to be waived as long as there's an attorney there. The appearance is made.
The appearance is made. Right.
That's
exactly.
brilliant.
For most of the what we call non-issue settings, right?
What else?
Wow, so much. I mean,
You realize
support
that you're revolutionizing this kind of stuff. You're on the forefront.
We're doing it. Yeah, we're leading the
Pretty
country.
amazing, I
It's a
think.
national model.
Yeah,
Is it?
national
Okay,
model.
talk to me about that. It's a national model. It's been used in nationally.
So
and other
who
setting
came
the
up with
standard.
it?
So the thing is, this has not really been done before,
Right.
and definitely not at this scale. And
We are
so
the national model.
We are.
Yeah.
We in Harris County are the national model
We're setting
in,
the
in the
example.
county courts. We are, and that's why it took so long. Here we are in July with our do or die setting, and it's because, look, we went down to the wire. Imagine too that plaintiffs and defendants, people suing us, you know, we ran for office. I ran for office to be a defendant in this case, to negotiate with people that I shared values with. And it still took us 7 months because the details, because we don't have a model to look to, except for what we made on the fly, implementing the rules, and that was informed, and our permanent decisions were informed by the temporary changes we made. So it was all this just like over and over. It is going to revolutionize.
Let's talk about. Oh, go for it.
The solution to bail reform is not just, oh, judges have to consider your financial condition before they can set bail. It's not just, oh, they have to set bail at an amount that you can afford. Like, the Fifth Circuit found that Harris County had intentionally engaged in, systemic violations of civil rights, equal protection, due process, for decades. And so in order to actually dismantle that whole system, there's many different parts of it. I mean, like the bond forfeitures is one thing. So, now Harris County is going to have to make rules to where they're not able to coerce pleas by, because it used to be if you were 5 minutes late to court, the state would move for bond forfeiture, the judge would forfeit your bond, and as soon as you showed up late, you would be in handcuffs.
Mm-hmm. On trial day.
Or shackles.
Shackles.
Be in chains, and they would say, well, if you plead guilty right now, you don't have to go to jail.
Can I speak to that? That is like, it's really close to my heart, that charade of the state's motion for bond forfeiture.
Shut up. Stay away from bond forfeiture. I just want to
and
quiet.
And I remember there was one judge who would be like, and that's granted every single time, and that's granted.
That'll be
and
granted, and that'll be granted.
Yeah, there's no such motion in the code. There's no such thing as a state's motion for bond forfeiture. There's just not, right? And so, like, as much as I hate using the courts for roll call, I was actually brought around to, like, let's know who's here, like that's not, as long as you take the coercive and punitive part out of the docket call, that actually just like, hey, who's here, right, in an organized way is okay, but we cut out the state's motion for bond forfeiture. It's just like, no, we're not making motions that don't exist anymore to kind of like for the DA to assert their power in the courtroom, right? Well, you don't have it, right? Not about this.
I would love to hear that'll be denied.
Yeah,
well,
that'll be denied.
Or we'll hold on that.
Yeah,
I mean, how hard is it to do this job well?
denied.
To like be like, all right, well, I'm not going to say right now because I don't know. Right? I'm just calling a roll. I don't have enough to rule on a motion.
Let's talk
So
about.
I've been playing with this a little bit, and I've had some cases where my client's appearance is waived, and their appearance, that decision was made 2 months before that court date. Right? I'm show up on that court date. And 2 months ago, the state and I, the prosecutor for the state and I, approached the judge, and I said, Judge, I'd like to waive my client's appearance at this next setting. I don't need him here. We're waiting on something that's going to take 3 months to come back, and court's in 2 months. The judge, with the prosecutor standing next to me, says, yeah, that's fine with me. Prosecutors, I got no objection. We all sign the reset. We write that on the reset.
Pre-trial calls.
And then, no, 2 months later, we show up for court. We're going to deal with the pretrial question next week.
It's a big problem, Judge.
But then 2 months later, we show up. Same people are all in the courtroom. That same prosecutor, that same judge, and me. The judge calls the name. The prosecutor, understandably, has forgotten 2 months ago that they agreed to waive the setting. The name doesn't get responded to. Maybe I'm not in the courtroom at that moment. State just robotically, state moves for bond forfeiture. Well, you waived his appearance previously. Isn't there a rule against making frivolous motion, knowingly making frivolous motions or knowingly filing frivolous pleadings in a court?
They wouldn't know, though.
But they were the ones standing right next to me, and they agreed to it.
We should tag them.
But
We
they
should
don't
put a post-it note around their
remember.
face.
Okay, but does the law say it's a defense if you file a frivolous motion accidentally?
I don't know.
No.
I don't think it does. And I also...
They're taught wrong.
They are
often
taught wrong. And the reason you ask them why they're doing that, they say, my chief told me to.
Right.
In fact, I was in court 4 a few months ago, and Judge Baldwin, very smart, recognized that there's this thing as bond forfeiture, and instructed the state, if you're going to do this, I can't tell you not to. You need to be saying state moves for bond revocation, which even to my ears is just like jarring. And she was sitting there, state moves for bond revocation, and she was getting like sneers and snickers from other attorneys who were giving her, she's like, this is what I'm supposed to say, the judge told me to. But she's actually doing it, if you're going to do it, the right way.
That is the thing that they can arguably move for.
Yeah.
That
You can move
right.
for whatever you want.
But and you know what's funny is that at an institutional level, the DA's office will complain bitterly about the difference between, and this is getting really in the weeds. I'm sorry.
That's my fault. I like getting in the weeds.
You know, it's when you don't show up for court, right? There are two options for a judge that are adverse options. There are other options like resetting the case for a couple weeks to let the person surface or not, and then take some adverse action or not. But you know, it's funny that they will bitterly complain. It's like, oh, we want you to forfeit the bond, not revoke it. And it's like, well, the law gives me two options. If both apply, right? If it's like a Venn diagram, right? Like if both apply, it would seem that I get my choice of which one to use. And you know, you can complain all you want, but yeah, institutionally they really want forfeitures because they
get to go after them for the money.
They get to go after people for money, right? And they, you know, I don't know. They've come to our judges meeting before and complained about this, and like we read them the riot act about it.
So let's talk about some things. Let's switch it up. Some of the new things that are going on. How about let's talk about cite and release. Okay, so currently in Harris County, you get arrested, you get cuffed, you get arrested, and you get sent to the new Joint Processing Center. You chill and watch some TVs. I'm kidding. You get arrested and you get locked up. Other counties in Texas do something called cite and release. And for the last 50 years, giving somebody a ticket or a summons to go to court was just preposterous, and they can't be done for these low-level type offenses. In other words,
About 20 years.
About 20 years. So let's say it's a low-level misdemeanor. Cop sees you, you get arrested and go to court. Drive my license out or something. I don't know exactly what it would apply to. Currently, you get arrested for that stuff and you go to jail. But instead of that happening now, you're going to get a date, like you get a traffic ticket and says you have to show up to court on this date. Is that my understanding what this new cite and release program that they're rolling out? What offenses does it apply to? Accusations does it apply to? And when will it start?
And who has to agree for that? Who all has to agree for that to be able to be possible?
That is a great specific question, you know, and the general question is the legislature authorized certain offenses can be disposed of or can be initiated by a ticket, right? Like we were saying last week, self-checkout at the Walmart, Class B level, graffiti, possession of marijuana, which they say they're not arresting people for to start with, but, you know, the numbers
I've
are
got
what
6
they
cases
are.
they need to like.
Yeah,
get in.
I have a ton of marijuana cases right now.
Right.
It's most Class Bs. Oh, you have a ton of marijuana cases, then those are getting dismissed.
They should
It's a
be
whole-
until,
trying to figure out what they're gonna do.
there's no policy or directive to anyone
There is a policy.
It
for
changes
for I think for
constantly,
arrest, like for more new arrests, but we're talking pending cases.
Yeah.
These people are stuck in limbo, and I'm just sending them for trial because I know they're going to dump them at some point. But the district attorney, at least through their office, hasn't let their line prosecutors know what they're going to do with these pending marijuana cases.
Oh, because the offense is before the hemp law.
Yeah.
Okay. Yeah.
Cite and release is going to be, we're going to create the infrastructure for police agencies to opt into this. And I can tell you, the sheriff's office on board, right? Because they're partners out on the street. They're partners also in court, right? They're good partners. The sheriff's office are great partners. They don't want their jail to be full up of people that shouldn't be in jail, right? And
They're
they
responsible for the JPC, for the more
They're-
humane treatment. That's
they're
the sheriff's
responsible.
office.
They do great work. They're great partners, right? And so I guarantee you there'll be a launch agency, right? We're going to create the capacity for people to write tickets. And it'll be up to the agencies, right? So, you know, when you see hashtag relational policing, ask what that means, right? I don't know what it means, right? Does it mean easing up in the way that everyone wants you to ease up? You know, it'll be up to them to tell us. So we are going to create the capability for people to do the thing that they're waiting for at the JPC. You're waiting in the waiting room. You got to wait to be printed. You got to wait to see the judge. You got to wait to talk to a defense lawyer, right? We're just going to do that where you don't have to go downtown and spend 24 hours in jail. You can show up to court and then wait to be printed real fast, go see the judge and get your case on track without disrupting your life in a way that the law and the Constitution say you're innocent.
That's
right?
amazing.
Why should your life be disrupted?
Have you? Are the particulars worked out on that?
Every week, every week we're working on it, right? And working on the details. One of the things in the settlement actually is this thing called open hours court, where if somebody misses court, we're going to publish that one day a week. We're going to start out at 1 day a week. There's going to be a court that you go to, like a standing hours court.
Nice.
If you want to get your bond reinstated, if you want to
Amazing.
explain what's happening, you got one place to go. You can always go to the court you're assigned at the time, any day, and say, hey, sorry I missed court. But there's also going to be a place you can go just to resolve your business without going back to jail.
Because people never know what to do when they miss court. They're just so afraid.
We're trying to make it simple. We're trying to make it
Annex
accessible.
court at City of Houston.
Exactly like the
Show
annex
up, you
court.
go to that window, they put you on the annex docket, and you go down at 9:30 at night and talk to that judge. And
Will there be
Right.
who will be running that bench?
Right
Yeah.
now, there were many iterations of it over time. Right now, what it's going to be a revolving kind of just like when you show up, they'll tell you what court's on that day. Is it court 8? Go up to courtroom 11-4.
Be like
right?
a warrant duty or something.
Yeah, kind of like that. And I have hopes that it'll grow into something that even the magistrates can do. Right? That give them some free world docket experience. Not just hold off in the jail. I think that'll make for better magistrates if we give them different settings and mix it up a little bit and treat them like judges, because they are judges, right? And so, it is a way that we are planting a seed to make a better system. We are making a better system today, but we're also planning to make a better system into the future.
So let me ask some specifics if you know the answer and if you can say. So let's say I get arrested or I get detained, I guess it would be, by a loss prevention officer when I scan some things at the Walmart self-checkout, and it's $150. It's a Class B misdemeanor, shoplifting, theft. The officer shows up. There has to be some coordination between the law enforcement agency and the DA's office, because the DA's office still has to file the charges, right?
So the way it'll work, yes, you're so right. The way it'll work is they'll have rules baked into their ticket systems like they have now for traffic tickets in municipal court and JP court, right? That they're like, all these ticket machines have these rules built in. It's just like, well, if you're in precinct 4, then it's the second Friday after such and such, right? And that's just the day you go. And then later, they give the paperwork to the prosecuting agency, be it the city attorney, the district attorney, and that's the way it'll work. They'll gather the information, they will submit it to the DA's office at a later date, and the DA's office will then have the time and the luxury to get all their papers together instead of being rushed down while someone's detained on a plastic seat at the Joint Processing Center. They'll be able to, take their time to a certain extent and then file the case when the person shows up to court is the idea, right? Is when the person shows up, then, and if they don't show up, then guess what? The case is being filed anyway, and then now they have a warrant out or they have a summons out or they have something out. We're working out the details. But it just takes a process that is too fast and too punitive right now and just breaks it up and slows it down and says, hey, here's your notice to appear in court 2-3 weeks from now, whatever, and, we'll get our paperwork together in the meantime. It benefits everyone.
Reasonable, thought out system.
It takes time to do. It takes time to...
That's just too
I
radical.
think that's great.
That's
I
too
think it's
radical,
great.
man. That's just too crazy.
Writing tickets.
That's too
writing
crazy,
tickets.
man.
Well, my
You're
own
crazy.
I do have a concern is that when things have a tendency to get erased, certain recordings and things like that, and that's one thing that my office tries to do is within 24 hours in a lot of cases we are issuing letters and preservation letters and trying to get subpoenas ready. And if certain counties that operate that way on just regular charges, they arrest them, book them in on a probable cause affidavit, and then give them a bond, let them out, and then 2 months later is our court date. Sometimes those people don't start calling attorneys for 2 months. And now I guess that's on the defendant, right? They got to know they got to step up real quick. I got this cite and release ticket. I don't have court for 2 weeks or 2 months or whatever, but I need a lawyer to get on this now and start preparing my defense, because the prosecutor, while they may be taking their time, they're preparing the prosecution, right?
Theoretically,
I'm
yeah.
not saying that's
Yeah.
a reason not to do this at all.
I
The greater
hear you.
good
It's
is
public
far-
education.
I hear
I
you.
mean,
Yeah.
stuff like that it's on our, you know.
We'll adapt. We'll figure out a way to get that stuff taken care of. But
I hear you that slowing down the process, that there are videos, there are surveillance videos and things that are destroyed over time, and it'll be something we have to work out, you know. But for now, I think not caging someone, not having people miss picking
That's
up their
far
kid
better.
from school or
Far
whatever.
better.
No, but you're right that is a concern, and it's something we gotta figure out how to do. One of the things we're working on with managed assigned counsel, right, which is something we didn't, you know, it's a lot to talk about.
We get there, marijuana and pro temps. We got 30 seconds.
Stay
So
tuned
you have
next
30
week.
seconds. So we can appoint lawyers earlier in the process as we professionalize the apparatus to appoint them and take it out of the hands of judges, right?
the MAC will absolutely be able to do that. That's a great idea.
So the idea is that more lawyers, better funded lawyers with more resources that are appointed earlier in the case by professional staff. That's put it on a bumper sticker. That's the MAC. That is the managed assigned counsel plan.
For Judge Franklin Bynum, the trial warrior Justin Harris, and extraordinaire lawyer PDO, amazing advocate Sarah V. Wood, unreasonable doubt. We love you.
Look up.
Looking up. We've been kicking some butt.
Yeah. Good show.
Yeah, we've been.
Really
great
good show.
Hot mic. PDO's kicking butt, getting not guilties. Justin Harris is getting not guilties.
Hey man,
Judge Bynum is seating the juries and changing the system.
Trying to put love into action, you know,
Love.
and the law into action for the first time around here.
It is bold. It is strong. Defense bar, keep it up. I love you guys.
yeah. So that whole national model thing, that's some pressure, right? Because if
Yeah, we got to
something
make
doesn't go right, then
the thing
everybody else
is-
will say, no, we're not doing what Harris County did down in Texas. 'Cause
That's right. But the thing is, like, we're gonna do it.
you will do it. You'll get it right. You got the best people in there right now to do this.
And also,
Never
your
have.
name's all over it.
Yep. That's right.
There it is.
There it
Judge
is.
Bynum is all over that stuff, man.
We the people.
On the settlement, I assume you have to sign it somewhere.
I do have to sign it. Yeah.
That's wild.
Yeah.
Did y'all
Yeah,
keep
we
Hey,
can
saying-
blood.
we should read Rule 9
Yeah.
July 4th of July.
Yeah, we should read Local Rule 9 on the 4th of
Read
July.
Rule 9.
Yeah.
Oh, yeah,
The
yeah.
bail reform rule. Yeah.
I love
No,
it.
we'll read that every year on the date of the settlement.
Yeah.
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 That'll be a new holiday.
Somebody will be like, I get Franklin Bynum's name.
Yeah, right.
Franklin
Yeah.
Bynum.
Franklin Bynum, Toria Finch, Harper Lee Wilson, Cedric Walker, Genesis Draper.
Daryl Jordan.
Yeah,
I want to read
Daryl
Daryl Jordan's name.
Yeah.
That'd be cool.
Yay, I got Judge Jordan.
Yeah, people will be like, yeah, I got Judge Jordan. Yeah.
Dude, I hope people saw your shoes.
Oh
know.
yeah, I was
I
saying,
know,
you
yeah,
should put your
Houston-
shoes right there in front of that
Houston
camera. if it
edition
came on.
Air Max
Those are-
97s. Yeah.
Are,
Love them.
Mike is
We're
still hot.
hot.
How?
Still hot.
When did those come out?
I don't
I think
know.
I've seen this-
Recently,
Okay.
but I got them on sale.
They have the area code on them.
Yeah, that's right.
both.
Got 713 on one tongue, 281 on the other.
I think I need some of those. Do they come in
Yeah.
other colors?
No, this is the only colors.
Are we still hot? Yeah.